During a medical malpractice trial, or even an accident trial or a wrongful death trial, if I am questioning my client on the witness stand, and now my client says something that I think is not correct or inappropriate, can I object to my client's own testimony? You want to know what this is all about? Come join me for a walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This question comes up because if you've been watching or you heard anything about the Johnny Depp Amber Heard trial, there was an instance where an attorney was asking Johnny Depp a question, and Johnny Depp answered, and the attorney objected to his own client's answer. Well, that drew a lot of laughs. A lot of laughs. Why? Because the attorney at that moment realized he asked a question to which Johnny Depp should not have been answering in the fashion in which he did. What am I talking about? The attorney asked Johnny Depp a question, and Johnny Depp answered the question, and the objection was hearsay. Now, what does that mean? So obviously a question was asked about something that he heard or something that he learned. And in response to that question, Johnny Depp, the actor, said, somebody else said, and now proceeded to give the answer. In that moment, when you hear that the witness is saying, hey, listen, I heard the answer from that other person, or I heard, or I was standing near other people, and I overheard them say, and now he proceeds to tell everybody in the courtroom exactly what he heard. That is hearsay. Now, what's hearsay? Hearsay is when a witness tells the people in court about something that he heard somebody else say. There's a problem with that. You see, if you're in court, each side has an opportunity to question the witness's credibility, to pick apart exactly the answers that this witness is giving. If he's now talking about something that someone else said, that person or those other people are not in court. And in many instances, the attorneys involved in the case have never had a chance to question those other people whom he is now saying said those things. And certainly the other side now is at a significant disadvantage because here is the witness, Johnny Depp, going ahead and testifying about something authoritatively, saying, yes, the answer is X, Y, and Z. Why? Because I heard somebody else say it. In that instance, that is considered hearsay. And putting aside the technical jargon, the technical definition of what hearsay is, in its essence, that's what it means. That the witness heard somebody else say something, and now he's telling everybody in the courtroom that's the real answer. Well, you know what? Maybe it is. But then again, maybe it isn't. The attorneys and the court and the jury and the judge will never know whether or not that's the real answer. Why? Because nobody has had a chance to question those people that the witness, that Johnny Depp is now relying on, to give that definitive answer. So in that instance, anytime you hear a witness start to answer a question by saying, I heard this person say, that's a trigger. That's a trigger for the opposing lawyer to jump up out of his seat and yell out, objection, judge, that's hearsay. And then the judge has to make a snap decision about whether or not that is correct. What's interesting is that in the Johnny Depp case, it wasn't the defense attorney, it wasn't the opposing attorney who jumped up to make this objection. Instead, it was Johnny Depp's own attorney who realized after Johnny Depp had said the information that that was incorrect and he should not have been talking about something that he overheard somebody else say. So he tried to correct it himself by yelling out, objection! And you know what? That's not really appropriate for his own attorney to yell out objection. You know why I think he did it? I think he did it because he got flustered and he realized after the fact that Johnny Depp, his client, had said something that he should not have said. So let me tell you one way you can handle that problem. So let's say Johnny Depp was asked a question about how he knew something had occurred. And now he begins to say, okay, I'll tell you how I knew it occurred. It occurred because during a phone conversation I had with Mr. John told me. That's the moment where the attorney should have said, hold on, Johnny, hang on. Don't tell us what you heard somebody else say. Tell us what you learned during your conversations with somebody else. Tell us how else you may have learned this information. So what am I doing? What I'm doing is now basically alerting the witness, alerting the court, alerting the jury to the fact that he should not be talking about things that he overheard somebody else say, and now telling us that that's the reason why he knows this to be true. In that instance, I'm not objecting when I shouldn't be objecting, but I am giving the witness a clear direction. Hey, listen, don't talk about things you overheard somebody else say. We don't know whether or not they're true, and we have no way of verifying whether or not that's true. So instead, tell us what you really know. Tell us about the information that you learned of personally. Tell us that you have information, and if you don't, tell us you don't know the answer to that question. In that instance, now we can go forward with what you actually know, with what the witness knows. But in this particular case, the attorney who represents Johnny Depp instead got flustered, and he realized after the fact that he shouldn't have asked that question because he knows that the only answer is, hey, I heard it from somebody else. In that instance, he's like, objection, that's hearsay. Well, yes, counselor, that's right, it is hearsay. But you, as the attorney who is asking the question, should not be making that objection, and instead, you should be quietly or jokingly telling your client, hey, Johnny, hang on one second. Don't go ahead and tell us what other people said. Tell us what you know. So why do I share this quick information with you? I share it with you because this just came up, and in fact, my daughter was following this trial, and I didn't know anything about it until she told me what had happened, and I read the news reports, and I actually heard the video clip, and I thought this was really interesting to share with you, to help you understand what happens when an attorney yells out, objection, judge, that's hearsay. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.